Today we're going to do an overview of healthcare directives, another video as part of our essential series about estate planning and probate. My name's Gregory Singleton. I'm an estate planning and probate attorney with Signature Law. Signature Law is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. If you like today's video, please feel free to like and subscribe. It really helps support the channel. Also, a couple caveats before we get going. First of all, these videos are for educational purposes only. I am not giving legal advice. And second of all, we're going to be talking primarily about Minnesota law here. So if you're in another jurisdiction, make sure to speak with an estate planning professional in your jurisdiction before you go plan your estate. All right, health care directives. I am a big advocate that believes that everyone needs to have a full and comprehensive health care directive. What are we doing with the health care directive? If you recall from our video on the universe of estate planning documents, we're handling your body autonomy while you're alive and incapacitated, and also we're making a few decisions and making our wishes known for what we want to have happen to our body after we pass. Essentially, a healthcare directive is two documents in one. First is a healthcare proxy, and second is the living will. Now, the healthcare proxy is a document that we appoint a healthcare agent. Sometimes they're called medical durable powers of attorney. We appoint a healthcare agent, a person and some successors who can make healthcare decisions on our behalf when we are alive but incapacitated. In the healthcare proxy, we're also going to identify what authorities they have and what authorities they do not have. Most of it will follow the statute, but there are some important decisions that do need to be made in the proxy that you should be going over with your attorney. Now, the living will is different. This is your medical wishes. It's not a medical order. That'd be a post or a DNR. But it is your medical wishes. If a doctor were to come to you while you're sitting in an examination room and say, do you want A or B? This is where you're going to write down, I want A. There's essentially, we're going to say about 5 things that we're going to be doing with the healthcare, with the living will. There's 5 topics that we're going to talk about in the living will. The first is you're going to identify your treatments, preferences, and certain declarations. These could be, if I'm in a persistent vegetative state, I do not want to have life-sustaining treatment given or life support. It can also be along the lines of, what are your goals? What are your fears about your healthcare? Or do you have any certain feelings about certain treatments that you want or do not want? Do you want experimental treatments or not? Etc., etc., etc. This is usually the bulk of the living will, where we're really getting into the nitty-gritty about what we want and instructing our healthcare agent to follow those instructions. After that, we're going to look at mental health, and I break into 2 parts. First is the Minnesota statutory scheme for mental health. There are 2 types of treatment, which will be electroconvulsive therapy and neuroleptic medications, that if you do not elect whether you want them or not, and a doctor comes to you and to you while you're incapacitated and says, I think he'd be good with neuroleptic medications, you need to have elected it in your health care directive, in the living will, saying whether you want them or not. If you don't have this, your healthcare agent may have to go to court to get court authority to either do electroconvulsive therapy and do neuroleptic medications, or to reject either one of them. Now, just a brief note on that, neuroleptic medications, these are pretty common medications. Do talk to a nurse or a doctor about exactly what they are, but they will include things like Abilify and Zoloft, some very common medications that we have that a lot of people are on a regular basis. Electroconvulsive therapy is not like the old movies where they hook electrodes up to your ears and they shock you with a whole bunch. It is more of a low-grade electroconvulsive therapy to make your brain operate properly. I'm not a doctor, I'm a lawyer, but that is essentially what they are. The other part of the health care directive for mental health is there are certain decisions that should be made that relate specifically to mental health and mental health care that you should include in your health care directive. It's going to be everything along the lines of, if you're treating with a doctor currently, is there any type of treatments or any medications that you do not want to have? What about being admitted to a hospital? Do you authorize it? In some states, you have to authorize it up to a certain number of days, or it's only up to a certain number of days that are allowed unless you authorize more. There's other things of, do you want to have certain treatments before being used seclusion and restraint, et cetera, et cetera, et cetera. There's a whole bunch out there. After mental health, we're going to look at end-of-life care. This will include things such as, where do you want to die? What are your thoughts about dying? Do you want to be in hospice care, inpatient hospice care, in-home hospice care? What do you want your family to do for you at the end of your life to give you comfort? Holding hands, read books, tell stories, play music, etc. What are your religious preferences? Now that we're at end of life, we're going to jump one more step and go to post-mortem, and this will be things along the lines of, do you want an autopsy? Do you want to be an organ donor? What do you want to have happen to your body after you die? Do you want to be cremated? Do you want to be buried? Do you want to be put in a sack and have mushrooms growing on you? That's a thing. One thing that I would note that is, if you choose cremation, make sure to state what you want to have happen to your ashes after you pass. I've seen a number of fights within families about what we do with the ashes after someone dies. The last thing we're going to include in the healthcare directive is going to be your HIPAA waiver. HIPAA is a law that says that if you, doctors, nurses, healthcare providers, insurance companies cannot give away your personal healthcare information, your PHI, without your authorization. So we need the HIPAA waiver to make sure that your agent is covered and can see your medical records. Also, if you want people other than your healthcare agents to see your medical records in case of incapacity, make sure to give a release for them as well. We are really trying to do 3 goals with the healthcare directive. First, we're trying to make our wishes clear. Second, we're trying to avoid fights within the family as they decide what care to give you. And third, the big one, we're trying to avoid court. Remember, court is bad. If we can avoid it, we do. We're going to meet these goals with starting with a healthcare proxy by making sure we include the healthcare agent and a number of successor agents and give them an order, so that when your relatives come to the hospital, they say, okay, Bobby, he's got priority number 1, but Bobby's in Mexico this week, so we're going to let Julie, because she's his next successor. That will avoid a lot of fights, and if it's clear, you don't go to court. The other thing to note is with the healthcare proxy, you can pick non-relatives. You do not have to pick your spouse. You do not have to pick your kids. You do not have to pick your siblings or your parents. You could pick your best friend if you don't think that somebody that you're related to is going to do the job. If you want to pick someone that is not related to you, make sure to include them in the healthcare proxy, because the default for most doctors is to find a family member related by blood or marriage or adoption. For the living will, the importance comes in clarity. Remember, you are making life or death decisions. Make sure your wishes happen if you're in that situation. Just remember, write it down, because first of all, people's memories are terrible. Especially in a highly emotional situation. They're going to start second guessing things and remembering things differently. And you might have sat them down and said something, but then an offhand comment you said later might make them second guess what you're doing. Write it down. We don't have to deal with that. Secondly is a lot of people think, I've told my spouse what I want if I'm in a persistent vegetative state, and we've gone through in detail what I want, everything I would include in a living will, so I don't need to fill it out. But the reality is, what if you're in a coma because you're in a car accident and your spouse is in the car accident too? Now we got to go to the successor healthcare agent to make decisions, and they're going to need it written down. Or maybe you've got 2 successors and a primary healthcare agent, and all of them are unavailable, and we have to go to somebody that is not one of your nominated healthcare agents. In that case, they're going to need it written down to know what your wishes are. Otherwise, they're just guessing, and when we're in a life or death situation, we don't want that. Now, the final thing that I would say is probably, one of the most important things about giving a gift with your healthcare directive is we want to give peace of mind to the person making the decision. Imagine this situation: your healthcare agent is at the hospital, you're in a persistent vegetative state, and you want them to cease all life-sustaining measures. Now, if they have to do that themselves and you haven't given them instructions and they're relying on their memory and such, it's going to haunt them for a long, long, long time, maybe years. But if your wishes are clear, if it says, look, if I'm in a persistent vegetative state and there's no chance of me recovering or a little chance of me recovering, please pull the plug. That gives them peace of mind and it will not haunt them for the years to come. It's a huge gift that you can give with your healthcare directive. It's relatively easy to do, so please make sure to do it. A few dangers before we go, pitfalls with healthcare directives. First of all, the biggest pitfall is ambiguity. Make sure you have your attorney walk through your language. If you say one thing in one part of the healthcare directive and then another thing in another part of the healthcare directive, or you're just not really clear, you could have a problem. You could even end up in court if there's a dispute among people. Another pitfall that people have with healthcare directives is that they're incomplete. They start filling them out and they just kind of stop. That just doesn't do any good. Another big pitfall for healthcare directives is people that just don't do it. That's the obvious one, but if you think about doing your healthcare directive, yes, it's going to take some time. Yes, it's no fun to do. It's going to cost you a little bit of money. But if you don't do it and you need someone to make decisions while you're incapacitated and you haven't done any planning, all of a sudden your relatives and friends and loved ones have to go to court and do a guardianship hearing, and that involves attorneys and judges and witnesses and evidence, and it's going to take a lot of time and $5,000 to $10,000 for something you could have covered with maybe $100. So make sure to do your healthcare directive. It saves time and money and feelings down the road and avoids a bunch of very unnecessary pitfalls. So that is my overview on healthcare directives as part of our Essential series. I hope you enjoyed it. If you did enjoy it, please hit that like and subscribe button. It really helps support the channel. We do new videos every other Wednesday. If you have questions, please leave them in the comments below or just send me an email. I'm happy to get back to you. Otherwise, until next time, this is Gregory Singleton with Signature Law.